Okay, continuing to address the news flashing on your screens with respect to Kotak Bank filing a writ petition at the Bombay High Court. We have with us Mr. HP Ranina and my research analyst, my colleague Poonam Sani as well joining in. Mr. Ranina, first over to you. Thank you at the outset for joining in on ET Now. Looks like the RBI, of course, of late has been in no mood to relax regulations, and they have outright rejected the plan with respect to the non-cumulative preference shares, perpetual preference shares that the company wanted to issue to sort of dilute down their Kotak stake. So how do you see this move playing forward now? Because RBI certainly has been very, very rigid when it comes to its norms.
Well, RBI is entitled to adhere to its norms. You can't go on changing the norms simply to suit a particular individual or individual company. Norms have to be applied generally to everybody. And if norms have to be made applicable, then certainly they should be, you stick to them. Because otherwise the credibility of RBI is affected. That they keep on changing their norms just to suit somebody's requirement. Now, these norms have been enforced. It is a part of the right of the RBI to fix such norms. Maybe some of those norms may not be, very in the liberal or in the interest of a particular investor or a particular company. But that does not mean that the RBI should keep on shifting its norms all the time. And I think Kotak Mahindra is only trying to get some mileage by, going to court, maybe get some stay order to extend the deadline from 31st December. And possibly that's the only purpose of doing this. But you can't challenge an RBI's regulation in the court of law simply because you are not able to meet with that regulation, or you think it is too harsh or too, constrained, or it doesn't in their interest. I mean, that may be your personal view. But that doesn't mean that the regulator is wrong in its approach.
Okay, so you can't challenge the word of law that has been put forward by RBI. But yeah, a writ petition at least has been filed. Okay, we have with us Abhizar Dvanji as well on the show. Abhizar, what do you make of this move by Kotak Bank? They are essentially filing this writ petition as they believe that their plan to issue those perpetual non-cumulative preference shares was more or less valid. And this was a way for them, for Ridho Kotak to dilute down his stake. How do you see this holding up in the court of law?
Yeah, well, I'm not a lawyer, so Mr. Ranina obviously has a better legal view. But if you ask me from a plain reader's point of view and from a commercial point of view, my view is as follows. Plain reading, it does not really say equity or preference shares. It just says shares or it says capital, and capital includes preference shares. So in that sense, technically, if one were to really read the word of the law, maybe there is a case. But if you look at in spirit, I think everybody actually meant equity. But a larger debate I think that this petition actually tends to drive through is the fact that is there really a need? I mean, is this only a compliance in spirit? And is there a larger debate to be said that really why do you need concentration in well-run companies which are professionally managed? And I think that is what this debate seems to head towards. Whether it's through a court of law or through through the media like yourselves. Really what it tends to say is, do we really need to have the level of dilutions that RBI prescribes? Is RBI correct in prescribing such norms? And I think there is going to be a lot more debate around that as against the simple reading of the law. So I do think that there is a strong debate around the fact that does everybody really need to dilute down? And if in that diluting down have we kind of achieve the objective of better governance? My view is not really based on what we've seen in the past.
Right. Mr. Ranina, this is Poonam here joining from the Mumbai studio. Sir, do you think that Kotak Mahindra Bank in fact is working really against the spirit of law now by filing a written petition in the High Court? And B, do you think that what could in fact be from a High Court, from a legal point of view, what could be the steps and further steps that possibly we can see, or the legal angles that we can expect on this front?
No, the High Court will interfere on a writ petition only if there is something done by RBI which is unconstitutional or which is contrary to public policy. So unless Kotak Mahindra can prove that their rights are affected in any way or that it is contrary to public policy, I don't think Kotak Mahindra should succeed in this writ petition. Of course, Kotak has taken proper legal advice and gone ahead, but my personal view is that this is just to pressurize the RBI to maybe extend the time limit from 31st December and give it another 3 more months, or maybe come up with some solution. Most probably the court will ask both parties to come to some reasonable solution and then come back to it. But otherwise, I don't think Reserve Bank's norms can be, so blatantly violated. And I again repeat that the Reserve Bank can't keep on changing its norms just to suit the needs of a particular company or a corporate.
Right. Mr. Diwanji, exactly, this is exactly the view that quite a few of the investors probably may also have, because if RBI is stating certain regulations and norms and Kotak is not being able to abide it, do you think that there is a possibility wherein if at all the High Court also states in against Kotak Mahindra Bank, and if at all it holds the view of RBI, then do you think that RBI in fact can go ahead and be slightly more stricter, just like RBI has been fairly stricter in the case of a Bandhan Bank or the recent cases of the small finance bank, and hence I guess the stock is coming under fair pressure in today's trade, Mr. Diwanji?
So one is that I don't think the RBI regulations per se mandate every company to lower down their equity. RBI regulations have come from time to time for specific instances and have required people to dilute shares as a direction. Now, obviously, there is discretion that the RBI has in this. It is not a carte blanche law which applies to everybody in a similar fashion. That's one. Point number two is that in this particular case, or every other case also, RBI has that discretion and it can use that discretion. It's not that there is a uniform law applicable to everything. So, horses for horses, companies or banks that you think need that diversification, or banks which have been run as personal fiefdoms, RBI has gone ahead and taken that action. RBI is a regulator which can take that action in the interest of governance. But where it believes that governance is right, I think RBI has the discretion, and it's not a plain reading of law, and that is what I think will get debated ultimately, to say that if it's in the interest of the banking system, why not?
Mr. Ranina, do you think that RBI can become stricter on Kotak Mahindra Bank even before we hear from the Bombay High Court, because the deadline is ending December 30th or end of this month itself?
No. What will happen is that the thing has been, filed in the writ petition is filed today. So before the Bombay High Court breaks for its vacation, some order will be passed. And therefore, that will take care of the 31st December deadline. In all probability, the court will ask RBI to extend this deadline until they hear the matter after the vacation. So that is what is going to happen. The whole object, as I said, is to make sure that this deadline of 31st December is, extended. And if it's done by the court, then that's the best thing that Kotak will achieve.
It seems so that this could possibly be a good method to probably buy time, and also hopefully RBI or Kotak Mahindra Bank may also be hoping that maybe they could get some amount of extension there. But Mr. Diwanji, do you think that post this written petition, do you think the Berkshire Hathaway story that the media has been really reporting in terms of Kotak Mahindra Bank, what is your sense or what is your view on the same?
Berkshire Hathaway is a different, again, as I horses for horses. CSB is a bank which requires control. It needs to be turned around. It's a bank which requires somebody to take full ownership, invest in management, invest in time, and turn it around for the depositors and for the banking system, and hence it's been given. So again, from a horses for horses based philosophy, the two are not comparable. I think Kotak should be assessed in its own limits, by its own merits, and thereafter a decision needs to be taken whether that should be allowed or not allowed. I think that's the stand that should be taken always in any bank in the country, and so I don't think the two are comparable.
All right. Okay, gentlemen, Mr. Ranina as well as Abizar, thanks so much for joining in then on ET Now, helping us dissect down this Kotak Bank news. Poonam, to you as well. Speaking of Kotak, the stock has certainly taken a massive hit post this news. It's just about near the day's low. A sharp slide has taken the stock price lower by 5.7%.